You're watching Live Now from Fox. I'm Daytona Everett. I am joined now by criminal defense attorney Vinoo Varghese. Vinoo, thanks for being with us here on the show.
Good to be here, Daytona.
Okay, so we all thought the Ghislaine Maxwell trial had a ribbon tied on it, a bow tied on it, and we're good to go, wipe our hands, but maybe not so fast. Federal prosecutors just yesterday on Wednesday requesting a hearing with a juror from the Ghislaine Maxwell trial who claims that his personal story of being sexually abused maybe helped him to convict Maxwell. First thoughts on this as a defense attorney?
You couldn't have asked for a better resolution, or I should say not resolution, a better outcome for Ghislaine Maxwell. Once she was convicted, obviously her lawyers didn't want her to be convicted, and they fought very hard. They were good lawyers, and they made the right motions, and it appeared that they had done a good job during trial, but they were undermined by jurors who just didn't tell the truth. This is a bombshell revelation, and we have to thank the media, because these jurors now come out and start talking. And this is a prosecutor's, I'm a former prosecutor, this is a prosecutor's worst nightmare. I can tell you that, having been a prosecutor, you were trained as a prosecutor never to speak to jurors. Why? Because you didn't want them to say anything that could undermine the conviction. It was sort of a don't ask, don't tell kind of approach when you're a prosecutor. As defense lawyers, we want to talk to jurors if we are on the losing side, right? So those times, I mean, I've won a ton of cases, I've lost a few, and those few really hurt, and you kind of want to know why that happened. So I had a case in New York County in state court several years ago, in 2000, well, I guess six or 7 years ago now, in 2015. In a kind of high-profile sex crimes case of a teacher at a posh high school, private school, most expensive private school in the country, who was accused and convicted of having a sexual relationship with a student at his school. And you know, the case, just the conviction shook my head, and I spoke to the jurors. And some of them were very open, and they said, you know, they had a couple things here and there and stuff. And one of them told me, and I remember asking one of the jurors about, hey, what about this? She says, well, no, I had a friend who was sexually assaulted, and that doesn't matter. You didn't bring that up during jury selection. You were specifically asked if you had any recollection, or you yourself, or you knew somebody, and you could come up and approach the judge privately and tell them about any experience that you could have that you've had that could have had an impact on this. She said, you know, she kind of hesitated. I didn't want to hammer her because this was now going to be my ally. Well, I make the motion, I put it in writing, and we're there, denied. Judge court denies it, and it got denied. Unfortunately, a different lawyer represented the client on appeal and didn't even raise this issue. So this was you know, when this came out and news of this with Maxwell came out, it was deja vu for me. The big difference is that you're in federal court. And in federal court, most of the time, you have judges who are going to take this stuff very seriously and not just rubber stamp. I mean, there's plenty of rubber stamping going on in federal court, don't get me wrong. But in state court, you know, and I imagine state courts around the country, I can only speak to New York. There's a lot of rubber stamping going on of the prosecution. And in this case, you have a judge, Judge Nathan, who's been promoted or nominated to be on the appellate court, one step below the U.S. Supreme Court, who's dealing with this case. And you've got also prosecutors understanding that their conviction is in jeopardy, who consented to have a hearing and suggested the court having, not the situation in my case with the Manhattan DA's office. So this is a bombshell revelation. The prosecutors here are doing the right thing by telling the judge they should conduct the hearing. The defense is taking it a step further, which I think is smart on their part. There's no reason to conduct a hearing, just grant the mistrial. I think probably the more prudent course of action is to have a hearing, because if the judge actually grants the motion for a new trial without conducting the hearing, then the prosecution could appeal that and then they reinstate the conviction. And then order a hearing, I should say. So there's much of, you know, different ways that this could go, but I think the judge will probably grant the hearing and do a hearing. And the reality is, at this point, it almost doesn't matter what this juror says during the hearing. And that juror is lawyered up, wisely so, right? Because that juror, there is no doubt in my mind that that juror hid that on purpose. There is no way in a sexual assault case. He says he just breezed through the questionnaire. Really? You're on the trial of Ghislaine Maxwell, one of the most high-profile cases in the nation.
I think it's important to note that in the questionnaire, there was specifically a question asking if your friend or family member or yourself have been the victim of sexual harassment, of sexual abuse, sexual assault. So could this juror be facing something?
Yeah, there's in my view, this juror has lied. And it did so deliberately, and then injected his own personal experience. So that's reversible on its own on appeal. So if it comes out post-trial that a juror injected his own experiences, and in this case, a sexual assault type case, that's clearly reversible. So I think the prosecutors are actually being smart here to an extent. And by saying, let's consent to the hearing, because if they oppose the hearing and the judge denied the hearing, that'd be automatic grounds for appeal. So the prosecutors are actually being smart here. I question the defense by saying, I understand they want the new trial granted. And there's an argument to be made that they have enough to grant the new trial without going through a hearing. I actually think there is enough, but the prudent, safer course of action for them as well, so that they avoid the government taking an appeal, is to have a actual hearing. And let me be clear, our government cannot take an appeal of a loss. So if there was an acquittal, they couldn't appeal that. But they can appeal a decision post-trial, either taking a certain course of action. So if the judge reversed the jury decision, the prosecution could appeal that, because they can argue that she should have respected the jury's decision. So at this point, it almost doesn't matter what this juror has said. He may take the fifth. I mean, if I were his lawyer, I would tell him to take the fifth. And either way, Ghislaine Maxwell is going to get a new trial.
What are the circumstances of that hearing? Is it just going to be questioning of that one juror, or are they going to bring back all of the jury members that he says he may have possibly swayed into a conviction?
It's a great question. It really depends on the judge. I think the initial questioning is going to be of the juror. I mean, the juror went on the news and said that he explained it during deliberations, his own personal experiences, and now it turns out a second juror has come out and said something similar. So I don't have the full details on that. I just saw that today. But this is a developing story. All in all, it means Ghislaine Maxwell is getting a new trial. I think that goes without saying at this point.
Yeah, and not to mention that, the trial date hasn't even been set for those two other perjury charges that are against her. So she still has, some courtroom exposure for her in the future, regardless of if this is a mistrial too.
Yeah, I mean, I'd be less worried about that. Because an obstruction and things, you're talking much less jail time than what she's facing over here. Generally, that's been the 5-year range maximum on those kind of things. But here, I mean, she's facing up to 40 years or around 40 years, and in essence, she would be spending the rest of her life in jail. So this is big, and this brings out a larger issue about the jury system. Jurors routinely, and this is showing this in a case like this, jurors are often not telling the truth. I've experienced it with a couple of the cases that when there's been a loss, interviewing, and then jurors say things, and you're like, and the problem here, and this is where I think ultimately all defendants will benefit, is that there's going to be hopefully lead to a greater scrutiny of jurors.
Yeah.
I mean,
what would be a typical consequence for a juror who lies under oath?
Prosecution. And so this juror is lawyered up, and wisely so. I mean, that story that the juror breezed through that part of the jury questionnaire. Come on, do you believe that? No one's going to believe that. There's no one going to believe that in this type of case. Oh, this is the most high profile or at least that and R. Kelly, two of the most high-profile sexual exploitation of minors case there is, and the juror didn't notice the question about whether he had himself had been sexually abused. Didn't the juror even take into consideration that he may not have been the best juror for this type of case? Right. And one of the things that I say during jury selection, and the problem is judges, and this is the problem in federal court, the judges don't allow the lawyers to conduct jury selection. The judges conduct jury selection. So the lawyers don't. This is a huge problem in federal court. There's only a handful of judges that will allow the attorneys to ask questions. Otherwise, they pose the questions, and it's like business. We got to get a jury picked. Most judges, the problem is, and this is where I said that there's less of rubber stamping in federal court, but this is actually something that comes out of this rubber stamping process. Judges say they're committed to fair proceedings, but most of the time, you don't allow lawyers to ask questions to kind of probe and develop these kind of lines of questions and stuff. And here's where doing a trial in the COVID age is even more difficult for lawyers. These people are wearing masks. You can't see their facial expressions because often it'll be a facial tick when that question is asked. I'm there, my associates, other people who I have watching the jurors for expressions. Much easier to mask those expressions, no, pun intended, with the mask on, right? So when you see that kind of movement, essentially you'll see people thinking. So you say to them, ma'am, Ms. Everett, I saw you had a physical reaction to this question. Can you please? I'd rather not talk about it. And understand, Ms. Everett, I'm not putting you on the spot, but if you'd like to speak about this outside of the jury, if just a judge and the prosecutor and me, then we could do that.
Right. Well, all eyes on that hearing as it comes up. That's ahead of the sentencing date, of course, as things will likely be stalled, correct, because of all this.
Yeah. She's not going to get sentenced. Not anytime soon.
All right. Well, we'll keep our eyes on the Ghislaine Maxwell trial as it continues to have twists and turns, as we imagined it would. We appreciate your expertise. Thanks for coming on the show.
My pleasure.